fact that there are a lot of intellectual property issues that come up. And so I said, well, I don't know a lot about intellectual property, but I do know somebody who does. And so why don't we get him in here to talk about those? So that's the reason Tim is here. And let me introduce you to him real quick, and then I'll let him take it away. Tim is an attorney with me at Bradley, Arant, Bolt Cummings. We're a full-service law firm here in Nashville. We have offices in several other states around the Southeast. We have about 500 or 600 lawyers total. That's a lot of lawyers, but that means there are a lot of really smart people there who know how to do most everything. And fortunately, we have somebody like Tim who knows a lot about intellectual property. Tim is a graduate of the Rochester Institute of Technology in Rochester, New York. He also has a law degree from Duke University, so he's very well qualified. He worked at Amazon before he came to work with us. And with that, I'm going to just turn it over to Tim and let him get going. Feel free to jump in with questions at any point. I know that Tim has a couple of different topics he wants to cover. And so he may ask at the end of each of those topics if there are any questions. But if you have a burning question at any time, feel free to jump in. We do want this to be interactive and interesting. So with that, I'm going to give it to Tim.
Yeah, thank you so much for that great introduction, Austin. And good morning, everyone. It's a pleasure to be here. I'm going to skip through some of my first slides here, introducing myself and Bradley. As Austin said, I've been practicing for a number of years with Bradley. My practice is focused on intellectual property law. I'm a registered patent attorney. I prosecute and prepare patent applications primarily in the area of medical devices. And then I have a large trademark and copyright practice. So I manage the trademark portfolio of a few hundred trademark applications and registrations internationally for global companies that include sports wear and apparel, consumer goods that you might find on the shelves of Home Depot, and being in Nashville, even a couple of country music stars, which is always exciting. So I'm really excited to share with you intellectual property, which is my passion, and the intersection with real property, which sometimes I feel like is my passion or at least a hobby. It seems like I can't avoid buying and selling property. I'm always engaging in some transaction and using services of realtors. So what is IP? What is intellectual property? So intellectual property is property, just like real property, except it's intangible. So that means you can't actually visit it. It's not personal property. You can't touch it. But nevertheless, it exists because the government grants a bundle of rights to exclude others. So just as you might exclude others with a fence on real property, patents, trademarks, copyrights, trade secrets are the fence that exclude others from practicing or implementing your idea or your expression or whatever the intellectual property may protect. So what are the different types of intellectual property? And this is a great question. It gets posed to me all the time by prospective clients and clients that confuse trademark and patent protection. So let's just do a quick run through of the different kinds of intellectual property. So first is copyright, which people tend to be pretty familiar with because it's in the news a lot and people are familiar with it from seeing it in books, etc. So copyright is the protection of expression in tangible media. So what's tangible media mean? It means a book, a canvas, even a computer hard drive, all qualify as tangible media. What is a patent? A patent is the protection of a new and non-obvious idea or design. What's a trademark? So a trademark is something that is source originating as to goods or services. And don't worry, we're going to dive a little deeper on some of these definitions. What's trade dress? So trade dress might be the overall look and appearance of something. So trade dress might include the way that the McDonald's restaurant looks, right? So it has a certain color scheme in addition to the golden arches, the chairs, the beverage machines, everything else might have a common theme or thread, and that's actually protectable under intellectual property law. And lastly, our trade secrets and right of publicity. So trade secret is anything that you keep confidential according to reasonable standards for your industry and size. And that could include something like customer lists, product formulas. So if you have a client list, for example, and you keep that client list confidential and take reasonable measures to protect it, like place a password on it, that could actually be considered a trade secret. And if someone wrongfully appropriated that, you might have a cause of action against them. So lastly is the right of publicity. That gets used the most frequently to protect famous people and use of their image or likeness. So if you took a picture of Dolly Parton wearing a new shoe line that you developed and started posting the image and marketing it, that could raise a potential concern that you misappropriated Dolly's image and name for commercial gain. So then kind of IP adjacent areas are technology transfer contracts, so the sale of technology, the patents and the know-how associated with that, as well as a myriad of other things, privacy policies and some other things that are gaining traction, especially in the news right now. So the focus of today's presentation is going to be on trademark and copyright protection. So what is a trademark? We said it was anything that's source identifying. When we say anything, we really do mean anything. So one example of trademark is a word. So Realtors or Realtor is a trademark, and it's a federally registered trademark. And we're going to dive in a little bit more on what Realtor means. And you can think of other examples too of word marks, whether it's real estate agencies such as Remax, Coke, McDonald's, all have very strong brands. It can be a symbol. So here we've got a symbol of the Realtors, the R on the face of a cube, golden arches. Any symbol can function as a trademark. A trademark can be a slogan. So here we have business objective, a life by design. So that's a registered mark by Keller Williams Realty. I was told that Keller Williams is pretty popular around here, so I tried to incorporate a slogan by them. And then a trademark can be a product or packaging shape. So that Hershey's Kiss shape that you see is actually a registered trademark to the Hershey Chocolate Company in connection with chocolate candy. And your own imagination is really the limit on what can be a trademark. So some other examples, some of these aren't as relevant to real estate practice, but they're still fun. So sound, the roaring lion for the MGN or the NBC chimes are examples of sound trademarks. Color, which could be relevant to real estate. So here we've got the blue box from Tiffany that probably many people are familiar with. A fragrance can be... a fragrance can actually be a trademark. So believe it or not, the Verizon store is associated with a certain musk smell, and that's a registered mark of the Verizon store. I have Verizon, and I've never appreciated the scent, but every time I go there, I mean to do it, but I'm always too busy comparing the new phones, and it seem to gets lost on me. So the design of a business establishment. So for example, we mentioned the design of McDonald's, and then motion. So actually the physical motion of something, if it's ornamental and non-functional, can actually be a trademark. So a classic example of this are the swinging doors on a Lamborghini. I wish I was more familiar with that, Austin. So if you're gonna be buying us trademarked things, I'll put that on my list. And then you have types of marks. So these are classic marks that are in use by the person who's trademarked them. So it's Tiffany in association with that blue, or MGM with the lion roaring, or Lamborghini with the swinging doors. Other kinds of marks include collective marks, and that includes the Realtor suite of marks. So collective marks are marks that are shared among a group of people, according to standards and a license. And then there's what's called a certification mark. The most famous example is that UL electrical symbol you see stamped on everything. And what that is a certification that a product meets a certain set of standards. And for that mark, the rights holder, so UL, actually can't use the mark themselves. They can only certify others as either meeting the standard. And both these require standards set forth that the users of the marks must practice. So is the trademark the same as a trade name or business name? And the short answer is no, but they can overlap. So, Remax is a trademark and it identifies a company, Remax LLC. And then they've got a variety of marks, including that hot air balloon that you see there. I just saw an ad on television last night, and the hot air balloon and that navy color were both pretty prominent. But with that said, the name of the company wouldn't have to be Remax LLC. And frequently it's not. So oftentimes brokers are a part of a franchise of a national company, and the franchise has its own business name. So a franchise might be named Dream Team Brentwood LLC, and they have a license from Keller Williams to use the Keller Williams mark. That's pretty common. So what you hold out as your brand doesn't have to be the name of your company. And sometimes that can be helpful. So you can make the name of your company something relatively banal and not interesting, and then develop the brand separately after you've incorporated. So why do we have trademarks? What's the value of a trademark? So the goal of a trademark is to indicate the source or origin of goods or services. If I say Remax, if I say McDonald's or Coke, you know exactly what I'm talking about. You know that if you get hopefully an Egg McMuffin at one McDonald's, it's going to be the same as another McDonald's, or one bottle of Coke is going to be the same as another bottle of Coke. And it's to protect that close and instant association with the good and the producer of that good or service, and the association that you've built up for it. So traditionally, when we think of trademarks, we think of it as protecting business, but it's actually to protect consumers as well. If you buy a Mercedes-Benz, you want to make sure it's coming from Mercedes, and it's not coming from someone passing off a lesser vehicle as a Mercedes. So the protection really flows both ways to brands and companies as well as consumers. And this dichotomy of protection for consumers and brands is important, and it contrasts a little bit with other rights that we also enjoy and have. So, we think about what trademarks are, and we said intellectual property is the right to exclude others, and includes the right to exclude others from using words, right? So that contrasts with our First Amendment rights, which are free speech. So how can a company prevent you from using a word when free speech says you can say, and write with limitations, whatever you want? So there is a balance there, and the balance will become a little bit more clear as we continue the presentation. But it's important to keep that in mind. And a lot of the limitations that are built into the trademark and copyright system are an acquiescence of sorts, or balancing with our free speech rights. So what are trademarks? How are they protected? So trademarks are protected first at common law. So if you hold something out as a trademark and you treat it like a trademark, it's automatically a trademark and you have common law rights. Now, those common law rights are not particularly robust. So most of the time, users and owners of trademarks seek registration. So there's two types of overlapping registration systems. One is at the state level, and one is at the federal level. Typically, if rights holders can get a federal registration, they will. A federal registration requires use in commerce. That's the hook for the federal government to have jurisdiction in trademark law. So in order to have use in commerce, it has to be interstate commerce and it has to affect interstate commerce. So, y'all over there in Bristol, Tennessee, it's pretty easy for you to affect interstate commerce since you border Virginia. If you were in the center of the state and you were very local and only, supplying real estate services to one particular town in the middle of Tennessee and you didn't have any out-of-state consumers and you didn't advertise on the internet, it likely would be difficult for you to have the in-use requirement of the federal registration system, but you could still get a state trademark on your name, and that would give you pretty robust protection at the state level as well. So when I say robust protection, you can't get monetary damages unless you have a state or federally registered trademark. So if you have a common law trademark, the only thing you can really do is stop someone from using it. And typically when I'm counseling clients, when you tell them that, when they come to you with infringement, they're mad, they want money. So if you tell them no, you can't get that because you don't have a registered mark, you kind of get the oh, that's too bad. So if you have a mark and you haven't registered it, think about registration and talk to an attorney about what that process is like and what it costs. It's really quite reasonable. So what is copyright? So copyright law protects the expression of facts and ideas in a tangible medium. So there's also a dichotomy here between expression and the idea itself. So an idea might be an apple, and the expression of idea might be an artist's painting and rendition of an apple. So if you were to get a copyright registration on your painting of an apple, you can't stop others from painting apples, but you can stop someone from copying your particular painting and expression of an apple. And that's true throughout the copyright realm, whether it's a textbook, a contract, a photograph, a real estate listing, a sound recording, etc. Copyright's always directed towards the expression of the idea and not the idea itself. So what must one do or not do to infringe a trademark or a copyright? So the test for trademark infringement is a likelihood of confusion analysis by the unauthorized user's use. So you will look at the similarity of the marks. The marks don't have to be identical. You can imagine if someone was using Keller Williams instead of Keller Williams for real estate agency services, Keller Williams would probably be upset, right? And they would have a good case. Another prong is going to be, what are the services? How related are they? So you can think of instances in which different users share identical marks for different goods and there's no confusion. So a classic example is Delta. So there's Delta for airlines, Delta for dental, and Delta for tools. No one gets those, or hopefully very few people get those confused, but they're all sharing the same exact mark. And that's because the services or goods marketed under that mark are so different, such as to avoid confusion. And some other relevant prongs are going to be the channels of trade and commerce, the relevant consumer and their sophistication, among many others. So what determines copyright infringement? So copyright infringement looks to see whether an unauthorized copy was made. Now, if you have a exact copy, it's been, literally Xerox copied, that's going to be pretty easy. It gets a little harder if someone modifies or changes a few things or creates what's called a derivative work based on the original work. So there are many tests to deal with that, but ultimately it looks to see how similar the works are to one another and whether access was available. So if the original work was published on the internet, for example, there probably would be access, and there's lots of cases on what access may be. So registration also exists for the copyright system. So again, you kind of get copyright automatically. The second you fix your expression to a tangible medium, you get a copyright. Now that copyright protection, again, isn't particularly robust. You're not going to be able to sue anyone for monetary damages. You actually can't even sue anyone in federal court. So if you're really wanting to protect your work, you're going to have to get a federal registration. And here, no state system exists anymore for current copyright. So there's only the federal system. And there is no jurisdictional hook of in-commerce here because copyrights and patents are provided for expressly in our Constitution. So the government registration systems exist, but the government's not going to do the work for you. I know that probably surprises many of you. Yeah. Exactly. It serves a similar purpose of putting others on notice as to your rights. So the burden is on the rights holder to enforce their marks or their intellectual property. And you'll notice for the tests of infringement on both trademark, copyright, and actually patents too, no intent's required. So it didn't look to see whether you intended or not to infringe the work or the trademark of another. It's just, is there confusion at the consumer level? Was a copy made? So kind of the innocent infringer argument, it doesn't work to cut against infringement. The only thing that may be relevant for are damages. Willful infringement, both on the trademark and copyright side, can increase damages awards, but they can't be used as a shield against liability for infringement. So how are real estate and IP related? And the answer is in many ways. So in addition to both being property and both being born out of the same legal regime at heart, the real estate industry is reputation based. So whether it's reputation of a particular agent or registration of a broker, registration of a bank, there's a lot of value to be had in the goodwill and name of those acting and practicing in real estate. So another are collective marks, obviously. The Realtor Mark is, I would say famous or should qualify for fame. And most real estate agents are in fact realtors and share that mark. And then contracts, web pages, listings, listing photographs. These are all things that are subject to copyright, and you need to make sure that you have a license to use and aren't infringing others, and we'll get into a little bit more about that later. But really, you're doing a lot to touch intellectual property. Every time you print off listings for your customers, you're implicating copyright and trademark law, whether or not you realize it. So let's take a look at the Realtor Mark. So up on the screen is the actual certificate from the federal government for one of the Realtor registered marks. So you can see here it's got a number of 519,000 and something. We're all the way to 5 million plus now on registered marks. So this is a relatively early mark, and that's going to be important in the strength. The longer you use a mark, the stronger the mark is. So we talked about how trademarks have to be in connection with particular goods and services. So this realtor registration is registered in connection with a variety of real estate services. So we talked a little bit about how marks, particularly collective and certification marks, need to have standards that are set forth. So we can see that the National Association of Realtors sets forth and publishes standards for its marks and use of its marks in a manual. And I'm going to click on the manual here, so bear with me. So here's the manual from the NAR about use of its marks by its members. So you can see it's pretty robust. The manual is at least 41 pages here. See, following examples are improper uses. So NAR does a good job of setting forth the standards of its marks generally, and what you need to use and what font and how not to incorporate its marks. So if you have questions on, what's a proper use of Realtor and the marks and what isn't, this would be a good place to go. And I included that link in the PowerPoint presentation slide. So before we get any further with our Realtor discussion, does anyone have any questions about intellectual property or rights infringement so far? Do we need to include coffee? Get people perked up a little bit this morning?
Do jumping jacks.
Okay, well, as Austin said, I was at Amazon.com in Seattle for a little while, so Seattle holds a near and dear place in my heart, although I'm very appreciative to be here in Nashville and enjoy the sunshine a lot more than Seattle does get to you after a little while. So in that vein, let's take a trip out to Seattle for our Realtor discussion. So there's dozens of litigated cases involving Realtor marks. Does someone have a question? Okay. So the case we're going to discuss is National Association of Realtors v. Champion Real Estate Services. So back in 2008, Champion's Real Estate Services, just by way of background, is a brokering and real estate company based out in Washington State. So it had multiple offices in the Seattle area. And in 2008, 2 of the real estate offices voted not to renew their National Association of Realtors membership for 2009. So thus effective in 2009, they were no longer going to be Realtor offices. So they were properly instructed by the broker and operator and owner to remove all registered and unregistered Realtor logos and marks on their web pages and marketing material for these offices to avoid problems of infringement. Since they were no longer NAR members, they would no longer have a license to use NAR's marks. So I imagine, I'm often told that managing lawyers is kind of like herding cats. That expression and analogy gets made a lot. I imagine managing real estate agents can kind of be the same because everyone's busy and operating independently. So perhaps unsurprisingly, a few of these members actually did not remove the Realtor marks from their web pages and their listings and their marketing materials. So what happened? Well, National Association of Realtors learned that despite not being NAR members anymore, a few of the agents and brokers were still using the NAR marks. So NAR sent what's called a cease and desist letter to these brokers, demanding that they cease use of the marks since they were no longer NAR members, and I'm sure inviting them to become NAR members again. But what happened, as you can probably guess, since a federal lawsuit resulted, this didn't happen. So the managing partner, the same one that had sent the email directing these offices and brokers to remove the NAR trademarks, circulated another email in response to NAR's cease and desist letter. So here's an excerpt, and this excerpt actually made it into the federal court's decision from the managing partner's circulated email. I'm going to read it just for emphasis. Any real estate agent may use and be called Realtor, whether or not you are a member of the Board of Realtors. All real estate agents are Realtors. The United States Supreme Court rules that no person can own any one word. You may use it all day long in ads, email, website, etc.
Exclamation point.
Yeah, exclamation point. This is what we call a smoking gun. So this managing partner, did not, I'm assuming or hoping, seek counsel before sending this email. This email emphasizes the importance of understanding the law before, recommending action to others. And, I won't resist using the pun. The email misses the mark. This is the wrong advice, and I imagine was highly persuasive in the court's reasoning and its result, which I'll hold for a little later. So, did NAR do, since the brokers and the firm did not remove the marks? They sued in federal court, alleging trademark infringement and unfair competition, asserting that Champions was also liable for the action of its brokers. So in this case, there were no actual factual disputes. So NAR was able to move for summary judgment, which just means the court can decide the case based on the uncontested facts. So what resulted? Well, NAR won. So the court set forth a great holding for NAR, and I'm sure that NAR probably has used this language in subsequent cases, that in this case, the undisputed evidence shows that the marks have been registered for over 60 years. The marks are used by approximately 1 million individuals in the real estate business and 1,400 local and state associations throughout the US. NAR also expends nearly $30 million per year in advertising to inform consumers as to the advantages of working with a licensed real estate agent. This evidence establishes that the marks are strong. So this exactly contradicts what the managing partner sent around in her email, that anyone can use the term realtor. In fact, NAR probably has done such a good job of protecting realtor that the managing partner was confused as to whether or not, realtor was a trademark, and whether or not realtor was synonymous with real estate agent. It is not, and this case is strong evidence of that. So what result? Champions and the managing partner personally were found liable for infringement under federal trademark law. So what did the NAR get? Well, they got injunctive relief, and then the parties were left to negotiate settlement of damages. So that isn't in the public record of this case. So, bottom line, realtor enjoys strong protection. And if you leave the NAR community, don't think you can continue using the realtor marks. Do we have any questions about that case before we move on? So what about copyright? How does copyright intertwine with real estate practice? So as we discussed, copyright law protects original artistic expression, and this includes in photographs, like listing photographs, and textual works, like listing descriptions. So remember, as we discussed, in order to get monetary remedies, you need to have federal registration of your copyright, or at least an application for registration for copyright. For now, that decision is actually going to be considered by the U.S. Supreme Court as to whether one can merely have applied for registration or actually obtained a registration. So that's an important footnote to that slide. And the default rule is that the author owns the copyright. This might seem obvious in some respects, like books, where when you buy a book from a bookstore, you don't think that you have a copyright in the original work. You just have a book that embodies the copyright, and then the right to sell that book to others, but not reproduce the book in a copier. In some other instances, the rule is a little bit less obvious. So if you buy a painting from an artist, an original work, the copyright actually does not by default transfer with the painting. So the artist still holds the copyright. So if you were to copy that painting and start distributing it, thinking that you own the copyright, you could potentially find yourself in trouble. And the same is true for photographs and for all other works as well. So, Everyone, I imagine almost everyone these days uses photographs in connection with listings. And probably what the listing is determines whether and the quality of the photographs used. I imagine some lower end listings, probably agents are taking their own photographs, and high end listings, you're going to be hiring a photographer to take professional pictures. So what are some implications on that? So if you're the photographer and you're taking the pictures for your listing, you're the copyright owner, you're the author. And then you're just giving your rights away in the form of a license when you share it with others and upload to the MLS listing. And the metes and bounds of that license are determined by the particular contractual relationship that you enter when you upload the listing and make that available. So if you have questions on that, take a look at the license first and then go from there. And then if you're using a photographer, it's important that you obtain the necessary rights in order to reproduce and make copies and share those photographs with others. So you want to make sure that in your employment engagement of them, you're either transferring the rights and the copyright to yourself or your brokerage, or obtaining a license that's sufficiently broad enough to protect what you're going to be doing with the photographs. So how do rights go to the MLS? Briefly touched on the participants in the MLS actually grant MLS a license to use and to share listings and the photographs, and then to actually share with others and make copies of the photographs, which you may say, well, that sounds weird. Why would we grant others the right to make copies of these photographs? And the answer is, a business decision of you want other buyers agents, for example, to be able to print off the listings and share them with their clients for reasonable business purposes. So that's what that is aimed at. So Trulia and Zillow are actually participants in MLS and other aggregators, and that's how they're getting copies of listings and photographs, is by virtue of being an MLS participant. They're part of the MLS license that likely grants them a right to use the photographs that are subject thereof. So, well, this is true most of the time. This isn't true all of the time. And Zillow has actually found itself in somewhat hot water as a result of its practices. So let's go back to Seattle for another high-profile case. This is pending reconsideration by the Ninth Circuit, which is the Court of Appeals for California and Washington State and Hawaii, that's below the Supreme Court. And let's take a look at what happened there. So VHT, the case is VHT Inc. v. Zillow Group Inc. And VHT is a preferred provider of exceptional real estate photography and marketing services. So basically, they're a photography firm, and they do photography work for high-end listings. I included a link to their website here, which I'm having a little bit of trouble pulling up, but they've got some beautiful photographs. I encourage you to go to the website and look at the properties. I took a spin through a few and was like, this is why I'm sometimes addicted to real estate. This is dangerous. So what happened? So real estate agents hire VHT photographers to photograph properties for listings. And the real estate agents were granted a license to use the photographs for marketing purposes. So the marketing purposes here is in quotes because A, it's a term that was used in the license, and B, it's highly relevant to our later discussion. So what are marketing purposes for? Now remember when we said that you grant a license when you upload to the MLS of the photographs that you're using or that you've taken. Just like in real property, you can't grant to others more rights than you have. So if you own Greenacre and Greenacre is 40 acres, you can't transfer to Austin 45 acres for Greenacre plus Blackacre. You only own Greenacre. Well, the same is true for intellectual property. If you only have a license to use a photograph for marketing purposes, and you want to transfer some of those rights to others, well, you're limited by what you own and what you have a license to do. So you can only transfer to others the right to use the photograph for marketing purposes, not some broader right that you don't have. So, unsurprisingly, Zillow grabbed thousands of photographs that were owned by VHT for listings and reposted on Zillow and Diggs. And to be honest, I had no idea what Diggs was. I had to look it up. I guess that means I'm getting old fast. So Zillow, Diggs is Zillow's home design site. I'm just going to describe it as being Pinterest-like based on my review. So it's just a bunch of design ideas and listings, and because the VHT photographs were high-end properties, I'm guessing that Diggs identified them as having a lot of design ideas for others. So VHT learned of this, and they filed suit alleging infringement of over 28,000 photographs. So first, Zillow responded they were covered by the real estate agents' licenses with VHT because they argued that their Zillow and Diggs postings were free to use for marketing and that they were using the photographs for marketing purposes, which on its face seems like a plausible argument, but if you dig a little bit deeper, it actually comes up a little short. So first...
there's another pun there. Dig and Diggs.
Yes, true. Thank you, Austin. So if you dial in, and I'm sure many of you have known that Zillow tends not to remove listing photographs of properties even after they sell, right? So I have a property in Nashville that I sold 2.5 years ago, and I can still go on Zillow today and look at the listing photographs from the property and reminisce about how all my projects were done and why did I buy a new property. And Zillow enables me to do that. So, is that really for marketing purposes, this archive that exists on Zillow? Probably not, right? And then second, the Diggs site, the Pinterest of Zillow, that is also, not really a marketing purpose. That has nothing to do with trying to sell the property that's subject of the photograph. That's merely design ideas and sharing with others. So that's what the jury found, and they held VHT the winner and Zillow liable for the infringement of VHT's photographs, and a jury awarded $8.3 million in statutory damages, which a judge later reduced to approximately $4 million. So this is a big blow to Zillow, not just for the monetary damages here, but for the precedent that it sets in the photographs that it reposts. So it's appealing the case to the Ninth Circuit on grounds that its use and reposting on Zillow and archival purposes, and I'm assuming it's Diggs as well, is what's called fair use. So there's a doctrine of fair use that developed for internet search engines like Google, Yahoo, et cetera, that says if a photograph is published and a search engine merely reposts that photograph to help others search, that there's no copyright liability. So Zillow's claiming an exemption based on that line of reasoning. So that's up in the air, and that's going to be highly relevant to Zillow's business practices and the way it treats photographs and listings. So before we move on from the Zillow and VHT case, does anyone have any questions about Zillow, Trulia, or any of the other kind of online aggregators?
Or photographs.
Yeah, or photographs in general. Anyone that's hired photographers or taken their own photographs that have questions?
Yeah,
What's that? Was there a question?
from using a copyrighted item. Never mind.
Is there any way to increase the clarity on our side? It's not coming through too well.
Don't worry about it.
I'm happy to answer questions in writing if our technology is failing us. So you're free to email me at tcapria@bradley.com. And I'm happy to share your question and circulate my answer with the group too. So what about the contracts that we all use? Are they subject to copyright, particularly boilerplate type contracts that have blank spaces? So, that's a great question. And here we have a purchase and sale agreement that's been posted by Tennessee Realtors. You see it's got that wonderful watermark that says draft specimen on it. And it's got some language in fine print at the bottom that says, this form is copyrighted and may only be used in real estate transactions in which insert broker name here, real estate agent here, is involved as a Tennessee Realtor authorized user. Unauthorized use of this form may result in legal sanctions being brought against the user and should be reported to the Tennessee Association of Realtors. So IP pop quiz, in order for Tennessee Realtors to get monetary damages for infringement of this contract, this form contract would have to be blank. So what would need to be done to this contract in order to get monetary damages? And the answer is the contract would have to be registered. It would have to be a registered copyright with the federal government. So what's the protection here on this contract? Is there a valid copyright that exists? So the short answer is yes. So NIMR is an authority on copyright. You'll see him quoted often in federal district court cases and others. And NIMR says that there appear to be no valid grounds why legal forms such as contracts, insurance policies, pleadings, and other legal documents should not be protected under the law of copyright. But remember, copyright covers the expression, not the idea. So contracts generally have a relatively thin scope of expression, right? I mean, they don't use flowery language that's done purposefully. They're pretty, factual and point-based. So, if you were to say in another contract, the purchase price of this residential property is X, and you were to copy that, that's really the idea, right? There's not that much expression in that type of phrase. So the level of copying that would have to be done in order to infringe a copyright in a contract is going to be a little higher than what it would have to be for another type of work. There is no hard and fast rule on what constitutes copyright infringement and what doesn't. So, obviously don't think that you can base a contract off a copyrighted contract. Certainly to look to another contract for ideas about what to include would be okay. If you find yourself copying language, or sections, or trying to think of different ways to just change a few words here and there, I caution you to stop and consider another avenue. So that's some of the ways that contracts are protected under copyright.
Tim, can I ask you a question?
Sure.
Your pop quiz said in order for Tennessee Realtors to get monetary damages, the form purchase and sale agreement that TR has developed would have to be registered?
That's correct.
Okay. Do you know if the form purchase and sale agreement is registered or not? Do you know?
I do not know.
Okay.
So that brings up a good point. So trademark records with the USPTO and copyright registrations are publicly searchable through the United States Patent and Trademark Office and the Copyright Office's website. The USPTO's website is particularly robust. You can search by an element of a mark, such as Remax or Realtor, or by the owner. So if you have a particular owner in mind, you can search by that and see if there's a registered mark. Remembering that oftentimes the owner may not be the brand name, so it could be IP licensing company LLC that owns a registered mark, like Keller Williams. So the Copyright Office's system is slightly less robust. It doesn't actually let you see the underlying work that's copyrighted. You can only see the title of the work and the nature of the work. So it very well could just say, NAR, TR, purchase and sale agreement form or contract, and you wouldn't know which contract that was. But it would at least tip you off that there are registered copyrights granted to the organization.
So let me ask you one follow-up question if I can. You were talking about the level of protection that's given to a purchase and sale agreement.
Yes.
And that I think you were saying basically it's kind of thin.
That's correct.
And so I was trying to think of another example. And so I'm thinking of Roy Orbison singing Pretty Woman.
Okay.
And so if somebody else wanted to sing a song about a pretty woman and it wasn't Roy Orbison's song, it wasn't his music and his words, I could sing a song about a pretty woman if I wanted to, as long as it wasn't his song, Pretty Woman. If I made up new words and a new tune,
that's correct.
That wouldn't be a violation of his copyright in Pretty Woman.
Correct.
Is that correct?
Yeah. So that gets to the idea versus the expression. So the idea of there being desirable pretty women out there that you may have a romantic interest in, that's not going to be able to be the subject of copyright.
Okay.
But your particular expression
like it's okay for somebody to write a contract to buy property.
Right.
I mean, I could write my own contract, and as long as I don't copy TR's contract, then I haven't violated TR's copyright. Is that right?
That's correct.
But if I start copying and pasting parts of their contract, then it starts to get closer to a violation of their protection that TR has for their agreement. Is that right?
That's correct.
Okay.
Yes. And we tried to find examples of cases that were brought by a real estate association such as NAR or TR, and actually didn't find any. And the reason for that, could be a business decision or that the cases get resolved before they result in federal district court litigation. Generally it's not a good practice to sue your potential customer base. It gets done in the IP world occasionally, such as, when the music industry got desperate against Napster and some of those other sharing services, they actually did start suing consumers. But oftentimes that's, viewed as a last resort, is suing your prospective customer base. It's just not a good business practice generally. So what are some things that you should be considering as you move through your real estate practice? So what about trademark? Well, if you're thinking of launching a new brand, or holding yourself out as your own brand with your own name, you should consider a clearance search by an attorney. So this is to take a look and say, well, let's just assume you come to Austin and you're like, Austin, I'm considering, launching with Remax, and I don't think there's any other Remaxes out there. An attorney is going to take a look and obviously find the fact that Remax is out there and has a suite of marks, and that's going to be a high risk to adopt and use Remax name or Remax marks. Obviously, most cases are much more nuanced than that, but it's always advisable to get a search for clearance, and that's a relatively small investment on the front end that really gives you, pretty good peace of mind moving forward. Another is register your marks. So, in order to get monetary damages, if someone opens up shop across town from you and uses your brand, you're going to need a registration. So consult with an attorney about registering your trademarks. You can seek registration yourself. You don't need to hire an attorney. The USPTO recommends that you do, and I also recommend that you do. It's quite complicated legally, and there are a lot of traps and pitfalls for the unwary. So another thing to think about is surname issues. So just like in law, real estate firms often use surnames. So to what extent are surnames protectable with respect to real estate services? So the answer is that they are protectable. but you need what's called acquired distinctiveness. So that can be had a number of ways, one of which is 5 years of continuous and exclusive use. And that only applies if you're using your surname by itself, not in combination with another surname in a generic way. So if you had Keller Real Estate Services, that would be a surname being used in a descriptive way. It's just Keller, which is easily recognizable as a surname, and Real Estate Services, which is generic for real estate services. Now, what about, Keller Williams Real Estate Services? So the combination of two surnames actually takes you out of the surname issue. So that avoids it pretty much entirely, and you don't have to worry about the descriptiveness issue anymore. So that's something to keep in mind. One limitation on surnames, if you use your surname by itself, is that you can't stop others that have the same surname as you from using the mark. So if you have Keller, Real Estate Services, and another Keller exists that opens up Keller Real Estate Services, the Supreme Court has ruled that, let's just assume there's no bad faith or anything, that there's nothing you can do. That was a limitation that you recognized and acknowledged when you adopted and registered the use of your surname in connection with your services. So another common issue is to use a trademark as a mark. And what do we mean by that? So ideally you want to use a trademark in a source identifying way as an adjective, not as a noun. So an example, it would be preferable to say hire a realtor real estate agent instead of just hire a realtor. Another would be, go make a Xerox of this or go Google that. It's really a Xerox copier machine and a Google search engine. So just be mindful of that as you, progress and use your mark and use the marks that you may be licensed to use, such as those of your brokerage firm and also, Realtor Marks. And then obviously avoid confusion with others' marks. So if you're using things that you think that others may be using as a mark, and sometimes you don't know, if you have a question, consult your brokerage and an attorney and get some clearance and idea of what you can and cannot say. And sometimes you run into things that you don't know are trademarks and they are. I mean, it happens quite frequently that someone will use something on their website, they come up with a slogan that they like, and it turns out that, someone else is already using the slogan before them and has a registered mark on it, and they get a cease and desist letter in the mail. The important thing is if you get one of those letters, consult an attorney. Don't do the reply email to everyone that says anyone in the world can use this and go ahead and use it and no one can stop you. That's a bad idea. So be proactive and tackle the issues on the front end. So what about on copyright? So you want to obtain a copyright ownership or license and photographs and listings. You want to make sure that you're the author or that you've been given sufficient rights to use the photograph and share the photograph and allow others to use the photograph in the ways that you need to. So when you're employing a photographer, make sure that your agreement with the top photographer expressly provides you with a license or ownership of the underlying copyright in the photographs. Generally avoid using others' forms, photographs, etc. without a license. So if you search online and find some sort of contract that you like, don't just download it and adopt it and treat it as your own. And this includes internet photographs and art. So I have a number of clients, some are well known, where their marketing department will come up with something new and they go and they're like, well, it would be great to get a cat looking out a window for my real estate website. I really think that would be a cute addition to my webpage. So they'll do a Google internet search, find a cat looking out a window, and put it as clip art on their website to spruce things up. Well, believe it or not, there's actually third-party aggregators out there who've got software that automatically scans the internet for their photographs that they've been given licenses to enforce. and basically you'll get automatically identified that you've copied one of their photographs and you're using it on your webpage, and you'll get a nasty gram generally by email or mail seeking some sort of monetary damage. So I've represented clients on those cases, and it's kind of a oops, the marketing department did this, and what are some ways that we can get out of it without paying. There's some hints in the slides for you, as well as I encourage you to retain an attorney to deal with those issues. So, and then consider registration of your own works. So to the extent that you draft photographs, contracts, listings, even something in your personal life that you think is important, artistic works, etc., consider federal registration of the copyright of those works. The registration process is pretty straightforward and simple and cost effective. So consider that on the front end, as that could be important. I'm at the end of my time. So does anyone have any questions?
Well, we've gone over by a couple of minutes, and I'll take responsibility for that by asking about singing about Pretty Women. But Tim, thank you. I do want to dismiss everyone. I know you all are busy. We are willing to stick around for a few minutes, though. If there are people who have specific questions, we'll stick around and talk. Also, phone numbers and emails for both Tim and I are in your materials, and we'd be happy to follow up on any specific questions that way as well. But again, we'll be here for a few minutes if you want to ask any questions. Thank you all so much, and have a good day.
Thank you.